Start. The petitioners herein are chartered accountants who have challenged the validity of Clause 6 issued by the Institute of Chartered Accountants of India (start hereinafter referred as Respondent Institute under powers conferred by the Chartered Accountants Act, 1949 start hereinafter referred to as the 1949 Act on the ground that the same is illegal, arbitrary and violative of Article 19(1)(g) of the Constitution of India. Some of the present writ petitions have been filed before this court under Article 32 of the Constitution, while others were filed before various high courts invoking Article 226 thereof. By order dated 9/12/2020, this court transferred the writ petitions pending before various high courts to this court. That is how, these cases have been clubbed and were heard together and are being disposed of by this common order. The controversy that has arisen in these petitions is twofold. Firstly, whether the Respondent Institute, constituted under the 1949 Act, had the competency to impose a restriction of the nature and effect herein, ? If the answer is in the affirmative, secondly, whether a chartered accountant's right to practice any profession as provided under Article 19(1)(g) of the Constitution, is unreasonably restricted by a ceiling limit imposed by Respondent Institute on the number of tax audits, under Section 44(a)(b), that can be accepted by a chartered accountant in a financial year? In other words, whether a chartered accountant can be restricted from undertaking more tax audits than specified by the Respondent Institute? Whether the impugned guideline is saved under Article 19(6) of the Constitution of India? It is apposite for us, at this juncture, to preface the origin of Section 44(a)(b) in the IT Act, 1961, popularly known as the compulsory audit provision, and the ceiling limit imposed by the Respondent Institute on the chartered accountants by way of a guideline, violation of which would result in a misconduct. It was further understood that information furnished by the auditor along with his certificate would enable building up of information for cross verification, leading to prevention of tax evasion and identification of new assets. It was interestingly noted that earlier committees and working groups had also deliberated on a provision providing for compulsory audit. In furtherance, it was noted that the working group of the Administrative Reforms Commission had favored compulsory audit by chartered accountants of persons with income over ₹50,000, but it was finally decided that due to limited number of chartered accountants at the point in time.